had 30 days to respond.
That was my question, is you definitely have 30 days, or it's relative to the auditor's decision that it's either 30 days or immediately?
I don't know, you're afforded due process under the APA. Jessica, did you have a comment?
I'm a little bit confused about what of all the suspension and abeyance.
Okay.
I just want that spelled out so it really makes good and easy sense for all of these.
Okay, it's active days of suspension and time held in abeyance. So let's say you create a violation and I give you 45 days suspension, but 30 days are active, and I'm going to hold 15 days in abeyance pending your promise to me that you're going to remain compliant for the rest of the license.
Okay. So basically the first time you sell to a non-qualified person, you're automatically suspended for 30 days as a center. Is that my understanding?
Yes. The recommendation would be a 45-day suspension with 30 active and 15 in abeyance.
Okay.
But depending upon the aggravating and or mitigation, you could accept a fine. As you know, for any violation, the licensing authority has the ability to fine you.
Okay. So basically, you're either going to be fined on the first offense or go to a 45-day.
That would be that would be the recommendation. But assuming that there are mitigating factors involved, the licensing authority may not see it that way.
Right. Okay.
Yeah. Go ahead.
Yeah, it might just be helpful, so we're talking about terms like due process and all of these hearings stuff, to kind of explain the process. Who's going to make that decision? Is it going to be the individual compliance officer? Is it going to be the director?
Good point. The way that this works is you receive a citizen complaint and or one of the compliance or the investigators is out on site and they see a violation. Just like anything else, they do an investigative report. The investigative report goes to a supervisor who either agrees or disagrees, finds that there's enough evidence, says you need more evidence, whatever the case may be, and this is typical in any law enforcement arena, as you know. Ultimately, it gets to a supervisor, and in this case, it's the division director, having been vetted through that entire process. Division director makes a recommendation based on suitability, and we bring the Attorney General into it. Attorney General looks at it, again, to make sure that there's statutory sufficiency there, that there is in fact a violation of a rule or statute, and then there's a charging document prepared. It's called a notice, notice of hearing. The notice of hearing under the APA, typically you're given notice and you have 30 days to respond. And feel free to jump in here if I screw up. You're given 30 days to respond unless it's a summary suspension issue. Again, one of those things that is a willful, deliberate violation of law or imperatively requires emergency action. You're given 30 days to respond to it, and typically we have what's called a pre-hearing conference. If Barb's business is the violator, Barb and her lawyer could come in and talk to Dan and our AG, and we would try to come to terms about it. And I have to tell you, it's almost like playing poker. It is playing poker from my perspective, because I'm going to show you what cards I have. And I'm not bashful about doing that. That's the way this process works. There's no hidden surprises. I'm going to tell you exactly why I think this is a violation. I'm going to show you all the evidence that I have in connection with it. And you get to decide whether you want to take it to hearing or you want to try and work something out. That's the administrative process on the front end. If we don't come to terms, then it goes to hearing. And the hearing process is actually before my boss, who is the state licensing authority, the executive director of the Colorado Department of Revenue. It's an evidentiary process. You first enter into an evidentiary phase where we play our cards, if you will. You have an opportunity to say why we didn't play our cards right or why we have a crooked hand or however you want to couch it. At that point, the licensing authority hears all the evidence. There's a record that's made for appellate purposes, and they make a finding. Either a violation occurred or it didn't. From that point, we go into the sanction phase. And the sanction phase is where we consider the mitigating and aggravating circumstances. I'm talking about the state licensing authority. We would present why we think there's mitigation present or why we think this is an aggravated circumstance. You would have the same opportunity. That information is given to the state licensing authority who finds a violation and levies a sanction. That process then is subject to what's called the Rule 106 action. It goes to district court in the city, county of Denver only. Statewide, it's the city, county of Denver. I believe you also have 30 days for which to file that, but if you want to continue to operate, you have to seek a stay. Court has to intervene and say, we understand that there's harm or whatever the case may be, and they will authorize you to continue to operate. Or you're subject to the days levied by the state licensing authorities. What have I missed?
If you're interested, I can give you the statutory site to the APA, if people are familiar with it. It's 24-105, that's the adjudicatory hearing provision. 24-4-105. And it's a pretty long, you'll have to go through. A lot of it is, it's kind of a long section, but that sort of is the general outline of how adjudicatory hearings are held and the notice requirements and things like that.
Now, what's important to know here, and what I haven't said is, I said it earlier, you could also be subject to a summons. We could write you a misdemeanor ticket, or perhaps that venue perceives this violation, whatever it is, a felony. There would be a felony filing done in that venue. Two separate actions. The evidentiary burdens are totally separate and distinct. Okay? One's an administrative process, as we said, is beyond a preponderance of the evidence, and the other would be beyond a reasonable doubt on the criminal side of things. Totally two different actions.
Do the days suspended have to run consecutively?
That's at the discretion of the licensee.
So
I've seen it done both ways, depending upon what the violation is.
Given that you're talking about the person being punished is ultimately the patient, potentially, is it possible that it could, that the suspension, if there was one, could be like Tuesdays, Thursdays, and Saturdays for 10 weeks?
It's entirely at the discretion of the licensee.
Is there anything that can be done in the recommendation to kind of put the potential for that into place?
What you're really talking about is a mitigating factor as opposed to an aggravating factor, and that's what we've done. Take it, spend some time with it. As I said, I think it's going to be probably the most contentious piece of what we do here, but it is a necessary piece, and it does maintain the integrity of the industry as a whole.
Sorry, Matt. Do the fines, will we be able to make the fine amounts in this room, or will that be determined by the SLA as the necessary?
We could make a recommendation if you want to go down that road, but yeah, again, yeah. It's about 25 after 2 now. I wanted to give the groups an opportunity to meet and subgroups and then come